Okay, we're on the last lap but one. And this is a round table on the way forward. And our three contributors here are Patrick Clark, who's a member of the European Disability Forum Executive Committee and President of Down Syndrome Ireland. And Patrick is Chief Executive of Down Syndrome Ireland. He has serves on the Board of Children's Rights Alliance and the governing body of the International Disability Alliance. At the European level, he's a member of the Executive Board of the European Disability Forum and chairs its Youth Committee. And he has a particular expertise in relation to the area of Down syndrome. Marion Harkin, MEP, is independent MEP for the North and West constituency of Ireland and was elected as an independent member and has been elected twice as a member of the European Parliament now. And she's a member of the Alliance of Liberals and Democrats for Europe, and she's a full member and coordinator of the Employment and Social Affairs Committee, a substitute member of the Agricultural Rural Development Committee, and a substitute member of the Petitions Committee. She's also president and founding member of the European Parliament Volunteering Interest Group and led the campaign in the Parliament to have 2011 designated as the European Year on Volunteering. Thirdly, we have Billy Hawkes, who's the Data Protection Commissioner, and Billy has been Irish Data Protection Commissioner since 2005. Prior to his appointment, he worked as a civil servant in various government departments, including finance, enterprise, trade and employment, and foreign affairs. In June 2010, he was reappointed to the post for a period of a further 5 years. Now, the format here is I'm going to ask each of our contributors to make contributions for about 10 minutes each, and then after that we'll have a questions and answer discussion. Thank you very much. So I'll ask Patrick to lead off.
Okay. Thank you, Chair, and good afternoon, everybody. And thanks to the NUIG Centre for Disability Law and Disability and Law and Gerard Quinn and Aisling for inviting me here to speak to you today on behalf of the European Disability Forum. This is a very important topic, and I'm glad to see that the Centre for Disability and Law and Policy here in Galway is leading the charge in this regard. I've learned an awful lot from the earlier presentations. I found them very informative, and even though some of them were quite technical, I don't think at any point we were sort of, well, certainly I wasn't overawed by the content, and it could certainly, and particularly in relation to some of the more technical stuff at the very start. But all of this will help me be better informed for my work with EDF going forward and the various work that it's doing in this regard. So EDF is it's a pan-European, pan-disability organisation representing over 70 million people with disabilities across Europe, and it is the interface of people with disabilities and the European Commission and Parliament. The national councils from each of the 27 countries of the EU, plus one or two more, are represented there, as well as all of the disability-specific organisations like Down Syndrome, the European Blind Union, the European Union of the Deaf, etc. So personally, as was mentioned, I represent people with Down syndrome, as I have a son with Down syndrome who's now 30. So it's a genetic disorder, Down syndrome, where there is extra chromosome material in the main on the 21st strand, as Professor Lowndes mentioned earlier this morning. And it invariably leads to varying degrees of intellectual disability, as well as some increased susceptibility to other medical conditions. I'm not a lawyer or a geneticist or a human rights specialist or a researcher or anything like that. I'm an accountant by profession, but I have 30 years' experience working on the issues that concern people with Down syndrome and improving their quality of life. As I say, today I'm here to represent EDF, and EDF has a long experience in this area going back many years, when it produced many discussion papers, among other works, but on this particular issue and policy documents, such as inequalities in health, which was an EDF response to the European Commission consultation in April 2009, a resolution on the active termination of life of infants with impairments and on the right to life, and that was done in May 2006. There was a resolution on prenatal diagnosis and the right to be different in 2003, and this was part and parcel of along with a position paper on the Groningen Protocol, which concerns euthanasia of severely ill children. So EDF has a long history and engagement on the topic, and this will continue into the future. It currently has a task force on stereotypes and access to health, which again is relevant to this topic, and it was where this all came out of an original bioethics group that EDF had. And as I say, access to health, or perhaps, as I say, it should be lack of access to health because a person's disability, whether or not caused by a genetic disorder or otherwise. Okay, I've been thinking on this topic all through it, and one of the roads, and there are many roads one could explore, and some have already been dealt with, but one topic that hasn't been broached upon yet is the area of prenatal discrimination against people with disabilities and even people without disabilities because of cultural issues around gender. And this, I believe, there is a private member's motion going through Irish legislature at the minute about the termination or because of gender issues in certain cultures. But however, of more concern to my constituency is the emergence of targeted prenatal screening and testing for Down syndrome specifically, and both New Zealand and Denmark are actively targeting Down syndrome for prenatal screening in this regard. The New Zealand Ministry for Health a report states that prenatal screening, prenatal testing is a cost-effective method to determine Down syndrome and the prevention of such births occurring. Denmark's health policy is that by 2025 there will be 0 births of babies with Down syndrome in Denmark. And in 2010 there were 25 babies born in Denmark, where given their population one might have normally have expected 120 to 130. Currently a group of parents from New Zealand who are being supported by the Harvard Law School Project on Disability, they're taking their government to the International Criminal Court in relation to this, to the specific targeting of Down syndrome. Papers have been lodged and it has been accepted that there is a case to answer. There are 2 cases where there is these are 2 cases where there is formal governmental direction targeting fetuses with disabilities. But insofar as sex selective screening invariably leads to selective termination, in some cultures offends human rights principles, a concern raised by various international human rights bodies and UN-sponsored conferences, so too disability selective screening, particularly for immutable disabling conditions, in the absence of any possible therapeutic purpose, should also offend human rights principles. Such policies reinforce stereotyping rooted in quality of life assessments made by medical professionals, politicians or civil servants, as opposed to persons with disabilities themselves and their family members. Pre-screening protocols, targeted or otherwise, as with other health policies, should be guided by the social model understanding of disability, and I believe this is not the case in New Zealand or Denmark. It is one thing to work to eliminate a disability in the person, but it is quite another to eliminate the person with the disability. Having said that, there are many countries where a lot of informal pressure is put on expectant mothers to undergo prenatal screening for certain disabilities from within the medical profession without any direct government directive. I can only speculate as to why this is occurring, but in our experience, where there is a positive diagnosis, little or no counselling is offered to the expectant mother. And we in Down Syndrome Ireland regularly get calls from mothers who have been given such a positive diagnosis for Down syndrome, but they've been abandoned by their medical advisor and they're not in a position to give any proper knowledge about the condition. So it falls then to Down Syndrome Ireland to give them the necessary counselling, etc., in a non-judgmental fashion so that they can make an appropriate decision. Some we never hear from again, and others we meet regularly then at various meetings that we would organise going forward into the future. So I welcome this discussion. I welcome the work that is currently been undertaken by NUIG and others in this area, and rest assured that EDF will be very happy to work along with the centre here and with others in progressing this into the future. So thank you for listening.
Thank you.
Very interesting.
Thank you very much. Marion Harkin.
Thank you. And is this working? Okay.
That is. Yeah.
Okay.
Clip this on for a hard.
Thanks. Yeah. Thank you, and good afternoon, everybody. And the first thing I want to do is apologise. I wasn't here this morning. I had another engagement in Athlone. I was speaking to a group of credit unions there. I suppose one of the things about being a politician is you have your finger in very many pies, and sometimes I think, and I'm not speaking about anybody else but myself, we can be jack of all trades and master of none. But anyway, I suppose in the context of this afternoon's discussion, the first thing I want to say is that it's not an issue about which I have any particular knowledge and certainly no expertise. But when Aisling contacted my office and asked if I would attend today, we didn't really know at the beginning whether I would or not, but she was insistent enough. And then we had a look at it, and I thought, yeah, this is interesting, and I certainly would like to know more about this. And when I say, having heard the last speaker, but also the two speakers before that, I really am sorry that I wasn't here earlier this morning, because I think you've been the recipients of lots of very valuable and useful and good information, and presented in such a way that even a jack of all trade person could understand it. But it's I certainly was very enlightened by some of the comments made by people, and by Pat there a few moments ago. Certainly you made a comment about eliminating disability in a person rather than eliminating person with disabilities, and that in itself is a very chilling statement. But however, it's funny sometimes though how things come together. I was just saying to Aisling, this week I actually hosted a debate in Strasbourg in the Parliament on personalised medicines and companion diagnostics. And of course this has quite a strong connection to your debate here today. Personalised medicines and companion diagnostics, according to the blurb anyway, aim at improving patients' health through targeting specific treatments to individual patients, or indeed groups of patients, based on certain characteristics. But of course, those characteristics are determined by genetic testing. So the advent of personalised medicine, from one size fits all to the right medicine for the right patient, will certainly drive the need for further genetic testing. Though having briefly spoke to Aisling during the break, this is happening already. It's happening even under our noses and we don't realise it. So personalised medicine, and certainly it's being pushed very much because, you know, we're told it has much better outcomes for the individual patient. It can mean fewer side effects from ineffective medicines. And of course, it can mean that somebody spends less time in hospital. And also, they say there are better outcomes for, you know, chronic diseases as well. Now, companion diagnostics, that involves diagnostic tests for selection of people for a specific treatment. And that can be achieved either by including those who are likely to benefit from the treatment or excluding those who would suffer side effects. So again, genetic testing is needed. And at the moment, there is a real push in the Parliament to inform MEPs about the current state of play and to lobby their support for legislation that will facilitate the access of patients to personalised medicine and companion diagnostics. So obviously this has implications. And indeed, one of the points made by the European Biopharmaceutical Enterprises and the European Diagnostic Manufacturers Association was that the development of personalised medicine and companion diagnostics requires use of genetic data, and that future data protection could limit this research. So they are concerned that data protection might limit the research here. So as you can see, we have tensions all over the place. So you see that conflict. They also tell us that the development of personal medicines requires extensive use of patient sample material. And it says that patients should be encouraged to give consent to the use of sample material for research purposes. And of course, that ethical committees and legislators should be aware of this requirement. So when you put all of that together, you can see the need that, you know, for some action to be taken so that we as politicians can keep up with medical advances and new medical technologies. Now, at that particular event, the European Commission spoke, and they spoke of new legislation that is coming down the tracks this year. The three big ones in 2012 will be the recast of medical devices, the clinical trials regulation, and the regulation on data protection. And in the context of data protection, we need to ensure that personalised data remains personal. And I asked the Commission official who was not an expert in this area, but I asked her if there were any plans to update the regulation in the context of our debate on genetic discrimination. And she did say that they really, in her view, they weren't planning to do much at this stage. But she did say that there was work ongoing in the insurance regulation vis-a-vis genomic requirements. So it was agreed also that the expansion of commercially available genetic tests, let's say for lifestyle diseases, etc., that also needs to be brought into legislation. So it seems to me that at the moment there is an inadequate response at European level. Now the committee, my main committee in the Parliament is Employment and Social Affairs. And as you already know, it deals with anti-discrimination. Oh, I'm sorry. Okay, that's fine. In the Parliament, we normally get 1 minute or 2 minutes. So therefore, you tend to speak a little bit faster. Sorry. As I said, we deal with anti-discrimination legislation in our committee. And you know the grounds on which we outlaw discrimination. They have been outlined for us here today. But one of the things that I find is when citizens come to me or constituents, people have an assumption that, that you cannot discriminate on any basis or in any situation. And they don't understand that it's actually quite limited. And people are actually very surprised to know that. And you also have been told by our Italian colleague about the fact that the latest anti-discrimination directive is actually stalled in council. The Parliament approved it. That would be, preventing discrimination on access to goods and services. So that would have widened the scope. And if we're going to talk about using that perhaps as a basis, it is worth noting that it is stalled in council, and that if we listen to some of the comments that are coming from different European leaders, particularly David Cameron in recent times, I mean, he's speaking about Britain having an opt-out completely from all social obligations under the treaties. He wants to go back to the 1980s. So how strong that is at European level, I'm not sure, but it is not something that can be ignored or indeed will be ignored. And I think that probably would indicate to us that extending scope of legislation may be particularly difficult. So I'm just throwing that in as a general comment. Now, as a member of the Disability Intergroup, it's interesting to note that there are no particular proposals from the Disability Intergroup at the moment. And as indeed, I had a few things written here and my colleague from Italy covered them, and let me say, in a way I would be unable to. But we have ratified the UN Convention on the Rights of Persons with Disability. And our Italian colleague looked at a number of cases in the ECJ. And while one of them I didn't recognise, the other one I did, the Coleman one, I don't think she mentioned that specifically. But that, I think, was an example of where the Commission were able to look at indirect discrimination. If I'm talking about the right case, it was about a carer in the UK. And they certainly did broaden, I thought, the remit there. And a lot of people were surprised at that judgment. But nonetheless, the Court of Justice tends to certainly not to grant rights beyond what one might expect in the directive. Now, we've already mentioned Article 21 from Lisbon, and again, I'm not going to speak any further about it, except to say that it really cannot function as a legal base as things stand. So therefore, we've got to look at either Article 9 or probably Article 19 as a legal basis. Also, of course, Article 6 of the Charter protects the right to liberty and security of persons. So I think there is no doubt that within its competence, the Commission has always been strongly committed to ensuring that those rights are enforced. But the issue here is within its competence. And while there may be some possibility of and you know that in July, the Parliament, in a resolution, supported further work on a directive on genetic data. But as far as genetic discrimination is concerned, I think it is uncertain at the moment. And again, I hope you don't mind, I'm going to finish up after this. an important point was made about the Equal Treatment Directive, the one that is now stalled in Council, by our colleague from Italy, because she talked about proportionate differences in treatment in financial services, and there was a massive debate in Parliament about that. A lot of lobbying on it, I can assure you, and it went through at the end, but it does say where age or disability are a key factor in the assessment of risk, then, you know, it narrows the scope. And I have no doubt that that will definitely impact on genetic discrimination legislation if we get round to looking at another directive on it. I'm just going to finish up by saying that our chairperson here spoke about our Italian colleague and how she managed to make simple something that was very difficult, and he said it's not her fault. And I was sitting down there and I felt like saying, well, it's not my fault either. But, but it's interesting that when we had our debate on the Lisbon Treaty, you know, you had certain persons saying that really we shouldn't be looking at a treaty like Lisbon, we should be looking at what they have in the US, for example. But then, of course, in the US, the interpretation of rights comes down to the Supreme Court and the judges that are there, whereas at European level, it's more political decisions. So don't ask me which is better, but that's the way it is. And maybe if we could find a balance between the two, it might be better. But it's interesting to think that our various treaties at European level cause such a problem for the judicial system. And maybe that is something we need to look at. But anyway, I'll leave it at that for the moment. As you can see, I'm not an expert in this area, but it's very interesting, and it is something we'll have to deal with. And perhaps we might look at raising those issues in Brussels at a conference or whatever to see if we can get interest in it and maybe talk to some of the people in the Commission. Thank you.
Thank you very much, Marion. One of the issues that people were talking about earlier was the information deficit which appears to exist between the areas of expertise which have been engaged here and the broader spheres which are where legislators must go. And certainly this conference, I think, has made an important contribution to this. The last contributor is Billy Hawkes, who's the Irish Data Protection Commissioner, and he's a member of the Article 29 Data Protection Working Party, and his chosen subject is the EU data protection perspective.
Thank you very much indeed, and thank you to Jared and Aisling for organising such a very informative conference. I certainly learned a huge amount about a topic that's of great interest to me. In my brief comments, I'm going to comment on the situation in Ireland as regards protection of genetic data, and then link it into the situation at the European Union level without duplicating the excellent presentation that Dr. Ferry gave us earlier on. So in Ireland, we have general protection of data of our data under the Data Protection Acts. A genetic test result is personal data. It is not, however, classified as sensitive personal data qualifying for a particular protection, except in the health context, which Dr. Ferry referred to as well. So basically, there is a basic protection of personal data, including genetic test results, under our data protection legislation. However, more important, in Ireland, we have the equivalent of the GINA Act in Section 4 of the Disability Act of 2005. Now, what's relevant here, I think, is that Section 4 is expressed as an elaboration of the Data Protection Acts, and it is quite clear in its provisions. It says that you need the informed consent of the individual before you process any genetic data. It prohibits the processing of genetic data in relation to any form of insurance policy, any form of pension, and any form of mortgage. And finally, it makes the processing of genetic data in relation to employment subject to the approval of the Office of the Data Protection Commissioner. And so far, we have never received such an application, so either people are breaking the law or it's not happening. I'm not sure. In any event, those provisions also attract penalties under the Data Protection Acts if they are broken. So therefore, it is a serious piece of legislation. Now, in relation to insurance, in order to make things clearer than they already are in the legislation, under the powers we have under the Data Protection Acts, we have approved a code of practice for the insurance industry, which is more explicit in relation to how this provision should apply in insurance. So it says that an insurer will not request an applicant to have a genetic test, that applications, any type of application form, may not request any form of genetic test. Likewise, whenever a request is being made to a person's GP, it must not include a request for any form of genetic test, and the wording should be clear on that. And finally, in the event that a genetic test, as it were, arrives in any event in an insurance company, they may not use it for the purpose of underwriting an insurance policy. So in other words, we have basic legislation in Section 4 of the Disability Act as elaborated on in a code of practice approved under the Data Protection Acts. Now we're going to be seeing some changes in the data protection situation. Potentially, the Section 4 of the Disability Act also makes provision for regulations about the processing of family history information for insurance purposes. Now, such regulations have not been made to date. That's a matter for the political system, but the potential to make them is there already in our legislation. Secondly, a review of Part 4, that's the part that deals with this issue of the Disability Act, has to be carried out not later than the 1st of January 2014, although it's likely, in fact, now that that provision may be overtaken by the new Health Information Bill, which is promised by the government and which is likely to deal with health information in a more comprehensive way. And finally, our data protection law is going to be changed arising from the changes in the data protection law which were mentioned by Dr. Ferry. And as Dr. Ferry said, we currently have a basic data protection directive at EU level, Directive 95/46 EC, and that is actually an internal market measure. It's based on the provisions in the treaty dealing with free movement of goods and services. And again, as with our domestic law, genetic data is not given special protection. However, the revised data protection law, which we are promised the texts of by the end of January, this is going to have the specific human rights basis which Dr. Ferry referred to, and a specific basis in the treaty, namely Article 16 of the treaty, which he gave the text of and which states very clearly everyone has the right to the protection of personal data concerning them. And this in turn is elaborated on by Article 8 of the EU Charter of Fundamental Rights, which spells out what data protection actually means in practice. So we will see in January draft texts from the Commission. Interestingly, it is possible the new text may take the form of a directly applicable regulation rather than a directive. Again, that has not yet been decided. The Commission has given different signals on this subject. In looking at what we know about what the Commission's intentions are, the Commission has clearly signalled the need to look at the potential need to include genetic data among the categories of sensitive data. The Article 29 Working Party, which I'm a member of, which is the Working Party consisting of European Data Protection Commissioners, has also come out in favour of having special protection for genetic data. And then, last but not least, the European population in general favours special protection for genetic data in accordance with the Eurobarometer survey, which was published in June of this year. So it is likely we're going to see in the new European law, the data protection law, special protection for genetic data. In terms of a way forward, and I think Dr. Ferry fairly put out the cases for a privacy approach versus a more horizontal approach, I suppose one question one could ask oneself is, given that we're likely to see a data protection law with specific provision for genetic data, one might ask oneself, is there any scope for, if you like, the Irish approach of elaborating on that provision within that new law and thus, if you like, providing comprehensive protection? I suppose the pragmatic bureaucrat in me says if you have a legislative vehicle on the stocks, that's the first port of call, and at worst you have nothing to lose by trying to get more elaborate provisions into that. But that's a more political point, and I'm not a politician. So thank you very much indeed.
Okay. say, on your behalf, I'd also like to thank Billy very, very much for his remarkably succinct and remarkably informative contribution. Now, what we're going to do just now is to take a very short break for 2 minutes to allow William Binchy to take his place up on the platform here in his capacity as rapporteur.